So, what's the absolute number one first thing you need for any crime to even exist? I mean, before you even start thinking about intents or harm, you need an act. But here's the kicker. What actually makes an act voluntary in the eyes of the law? Well, today we're going to break down the Model Penal Code's answer to that exact question. So, let's just jump right in with a classic head scratcher. Can you be found guilty of a crime for something your body did while you were totally asleep? It sounds kind of philosophical, but it is a real deal legal problem, and it's precisely the problem that Section 2.01 of the Model Penal Code was built to solve. All right, let's get into our first big principle, the voluntary act rule. You should really think of this as the absolute bedrock of criminal law. It's the first hurdle any criminal case has to clear. And here's the rule itself, straight from the code. The key words you've got to lock onto are conduct that includes a voluntary act. This is huge because it means the law isn't really concerned with who you are or what you're thinking or a condition you have. It's all about what you do. I mean, every single offense, from a little traffic ticket all the way to the most serious felony, has to be based on a voluntary act. No exceptions. This quote from the people who wrote the code really drives the point home. You can't be prosecuted just for having bad thoughts. You can't be prosecuted for a physical state, like being sick. The law only gets involved when a thought turns into an action. You know, this line between what's in your head and what you do in the world, it's a fundamental pillar of our entire legal system. So what in the world counts as voluntary? Well, the code does something pretty clever here. Instead of trying to give us some long, complicated definition, it just makes things crystal clear by telling us what is not a voluntary act. And check out how specific this list is. A reflex, like when the doctor taps your knee and your leg kicks out, that's not a voluntary act. A convulsion during a seizure? Nope. Any movement your body makes while you're asleep or unconscious? Definitely not voluntary. And then they give us this critical catch-all at the very end. Any movement that isn't a product of your own effort or determination. Simple as that. This chart really lays out the dividing line perfectly. A voluntary act comes from your will, your choice, and that includes habits you don't even think about, like driving home on a route you've taken 1,000 times. But an involuntary movement, well, that's something your body does to you, not something you do with your body. And that single distinction changes everything. Okay, so we've established that criminal liability needs an action, but that brings up a really interesting question. Can you be guilty for not doing something? This is where the law wades into the murky waters of omissions, or a failure to act. It feels like a total contradiction, doesn't it? If we're saying all liability has to be based on an act, then how can you get in trouble for doing nothing? Well, the Model Penal Code says yes, you absolutely can, but only under a couple of very specific circumstances. So, there are only two ways this can happen. The first is if a law explicitly says you must do this thing, and you just don't do it. The second, which is a bit broader, is if you already have a legal duty to do something and you fail to follow through on that duty. And here are two perfect examples that make this super clear. On one hand, the law expressly requires you to file a tax return. If you don't, that's a crime of omission. On the other hand, the law imposes a duty on a parent to care for their baby. A parent who fails to feed their child can be held liable for that omission, because that legal duty was already there. All right, let's tackle one last special case, possession. I mean, how can just having something be an act? It feels totally passive, right? But the code is really smart here, and it reframes the whole thing so it fits perfectly into the voluntary act framework. So, possession only counts as an act if one of two things is true. Either you voluntarily acted to get the item in the first place, you knew what you were doing when you got it. Or if it just sort of landed in your lap, you later realized you had it, and you had plenty of time to get rid of it, but you chose not to. So here's the bottom line. The law finds the act in one of two places. It's either the positive act of actually taking possession, or it's the omission, that failure to do something to get rid of the item once you know you have it. You see? This connects the whole idea of possession right back to the main rules we've already been talking about. It's actually a really elegant solution. So let's wrap all this up. What is the one thing you absolutely have to remember from Section 2.01? It's this. The rule acts as the essential first gate for all of criminal law. We're ending right back where we started, with this core rule. This is always the first question you have to ask in any criminal case. Before you start worrying about what the person was thinking or what their motives were, you have to find the act. And that's exactly why this matters so much. If you can't point to a voluntary act or one of those legally recognized omissions, then the whole analysis just stops, dead in its tracks. There can't be a crime. It's a really powerful, clear-cut rule that protects all of us from being punished for things that are simply beyond our control.
But of course, finding that voluntary act is just step one. The act itself isn't enough. It has to be paired with a certain state of mind. So what was the person thinking when they did that voluntary act? Well, join us next time as we dive deep into the fascinating world of mens rea, the mental element of a crime. We'll see you then.